Good evening, everyone. It is Friday, the 20th of March, and we are joined tonight by Alison and Michelle. We want to just bring you up to date with where the bill is at right now. What are the things we need to know? We have noticed that a lot of people are confused and a lot of people are panicking and a bit frightened. So we're going to just say where things are at right now, and hopefully that will help to clear up any confusion. Please bear in mind that nothing is set in stone yet. There's still change. This is still in flux. Some of the things we show you, you may see numbers are not relevant anymore, or we don't know if they're going to be relevant because they keep adding little bits into the bill. For instance, the social media stuff, which can also affect where things are ordered in the bills. So this is very much a document that is still in flux. And all we are doing is saying this is where it is at right now. It has left the House of Commons again. It's been pinged in the House of Commons, and they're pinging it back to the House of Lords, where they'll be discussing it this week on Wednesday, 25th of March. So, and then
but they will be ponging it. You said
they will pong it.
So now they're ponging it. Yes.
Yes. We're going to see. There's some things we don't really expect will change too much because of the government's majority, and we know which way the wind is blowing. But
the other bit is why we know certain things are not going to change is because with ping pong, once both houses have decided that they agree, then that bit's done. So why we can talk with more confidence on the children not in school area is because the majority of the amendments the House of Lords had put forward, the House of Commons accepted. And the few that they didn't, one key one, they gave financial reasons. And the House of Lords, through various constitutions, are not allowed to impose a financial burden on the House of Commons. So they can discuss things that may nuancely change, but they can't put extra budget costs onto the House of Commons as the House of Commons accept them. So that's why there are other sections in the bill we couldn't talk as confidently about because they're still not agreed. But most of the children not in school stuff, the House of Commons either accepted in the complete way it came to them, or they rejected in a way that it can't easily be brought back in any shape or format. So we're pretty sure this is quite far through. But you also need to bear in mind the reason people are confused is because there isn't a nice, tidy document at the moment. At the moment, you're looking at the different areas of the ping pong. So we're looking at the House of Commons bill when it left there, which was last year. We're looking at the House of Lords bill when it left there, which was earlier this year. And we're looking at the amendments that have already been looked at, that page. And then we're looking at a page that tells you what they've disagreed and why they've disagreed for the House of Lords to then consider the disagreements. But it's only those disagreements or any new bits. I think they've added something extra to the allergy bits in the last few days. Any new bits to nuance that will be discussed. They will not be discussing the stuff which the House of Commons have already accepted from the House of Lords.
Yes, and also to say that the way in which this bill, if it gets royal assent, the way in which it is enacted is also going to depend a lot on then regulations and guidance and those kinds of things. Even then, we are supposed to have some input in respect of guidance and that kind of thing. But this is where we can only say to you what the bill says. We can't say exactly how it is going to be carried out. Obviously, people have their concerns based on track records of their local authorities and all of that, but we cannot say this is how it's going to be. There's a lot of wait and see going on. The very first part of the bill that we want to discuss, and these are only the sections pertaining to home education. We're not touching a single unique identifier at the moment either, because there are other people that are dealing with that, and you can go and read up on that elsewhere. But just the bits that pertain to home education specifically. And the first one we're going to discuss is to do with the consent of the local authority.
At the moment, you don't require consent to home educate unless you're subject to a school attendance order or something like that.
Oh, and in the special?
No.
Isn't that still?
No.
Okay.
No. So at the moment, the case that people think is consent to home educate that is not, is consent to take your child out of special school. And that was just intended in the original legislation. It was just intended to make sure that things were in place and you were ready, basically, and that they could give that place to another child because they're in short supply. It was not consent to home educate, and there's never been consent to home educate. This changes now with this bill. When it comes to special schools, instead of consent to deregister, you now will have to seek consent to deregister and home educate, and that consent will be granted if the local authority considers it to be in the best interest of your child to be home educated. So it doesn't matter how good your home education is, if they consider that little Johnny gets something out of going on the minibus to special school, even though his education is less good, and that that's more in his best interest than having a better education, then they will say no. So that's where that comes from. It's a very, very muddy term, best interest, isn't it? It's not very quantifiable. So we're going to wait, and we've got to see how this plays out.
And this is 434A, correct?
Yeah, I believe so. Yes. And then the other consent categories that they've brought in with amendments are if you have, your child has been on a child protection plan in the last 5 years, then consent must be sought. Or if they are currently on a child protection plan, or they are currently subject to a Section 47 investigation, which is a child protection investigation. So that's before you get to the child protection plan, but they're doing the investigation. And in all three of those circumstances, yet again, it will be if it's in your child's best interest. That makes it a bit sticky for some people now, but it is a very small proportion of the population that's going to affect.
And this is also, the amendment is now that if they've had any inquiries or so on in the last 5 years, is that correct? Did you mention that?
Yes, yeah. If they've been actually on it, not had an investigation in the last 5 years, but if that investigation has led to them being put on a child protection plan, then you will have that barrier, you'll have that hoop to jump through.
This will affect you, yes.
Yes.
Okay, so are there any other consent categories, Michelle, that we've overlooked?
No, I think we've covered the consent ones, and it's if the LA considers that it is in the best interest for your child to attend school. So it's not even necessarily going to have to consider the home education, which is the other bits. And we will have to wait till that guidance consultation comes out, and we will need to be putting in there as a community what we think should be included in these best interest assessments, because it isn't a thing at the moment in any shape or format. It just doesn't exist.
And
this particular decision.
Yeah, and they won't have considered the things that we know about, like, for example, they won't have considered that if your child's mental health is being adversely affected by being at school, then clearly their best interest is to be home educated if they're going to get an education and their mental health is going to be better. But they won't think about those things. So it's up to us to make sure that when we get the opportunity to speak up, that those things are considered.
I want to just address a question that's come up. What if the child has never been to school? So the consent would only apply if that child has been the
on a child protection plan in the last 5 years.
Plan. Yes.
Or currently on a child protection plan.
Other than that, this would not apply to that child.
Correct.
Okay. So then, but the next thing will, and that is registers. This bill wants to introduce a children not in school register. And this is section 436B and 436C, where you can find the information on the register.
Can I just say the numbers that Juliet's quoting here are the sections that will be inserted. What this bill does in these circumstances is it alters our current Education Act 1996. So it inserts things in, it slots things in between other things. And so why it says 436C, etc., is because it will be inserted after. We only have a 436A at the moment in the Education Act, and this adds a million different alphabet letters after that.
Yes,
yeah,
so
and if you look on these, they're capital letters. So when it goes into the Education Act, when you look through acts, if they're little letters, they were in the original legislation. When you get capital letters, it's an amendment that's been inserted in at a later point. One of those weird little facts.
Interesting to know. So 436B is about the duty to register children not in school. and it talks about the different conditions. One of the confusing things about this bill is it refers back and forth, and you have to go and have a look what it's referring to. Conditions A to C, whether the child is living in the authority's area, is compulsory school age, and going to attending school, basically. They would then be eligible to be on the register for children not in school.
Makes it sound like a privilege, doesn't it?
Yes, I wouldn't be eligible for £1 million, but okay. So,
can I just answer the question in the chat? The best interest test is the categories we spoke about. So that's if you were deregistering from a special school, that's the child protection plan, and it's the Section 47 inquiries. So it is all three of them will now be subjected to the best interest test. And yes, we have all raised numerous times with the DfE that this looks like baking in disability discrimination into the law. Unfortunately, this is where we're at.
Yeah. And as time goes on and we have consultations and we have opportunities to watch this space, because every time we have an opportunity to raise our voice about that, we will be encouraging you to do so as well. So keep your ear to the ground, keep watching us, keep listening to us, and we will let you know when your opportunity to mention the discrimination can come in.
Okay. So going back to the registers, what are they going to want on this register?
Well, before we get to that, you have to make sure that your child is put on the register within 15 days of commencing home education. That means 15 days of taking your child out of school, or 15 days if you've never home educated or sent your child to school before or anything. And so as soon as they reach compulsory school age, that's the beginning of the term after the term in which they turn 5, within 15 days of the beginning of that term, you will be eligible to go on the register.
Yes, I think it's better to put it that way. You know, you would be expected to, because obviously that can be a matter for personal conscience, but it will be law. That's where we're at right now. So what is the information they're going to want? Child's name, date of birth. They have changed one thing, which is like instead of the amount of time that the child spends receiving education, it would now be an estimate of the amount of time.
Yeah.
So not like exact time.
And so they want details of both parents, and they want details of the home addresses of both parents. So they want
here the changes are that they made the amendments here. It's a child. So the other amendment was that they also want, if you've lived at your address less than 12 months, they want your previous address as well.
Well, previous addresses, it's that they need the addresses for the full 12 months.
Yeah. What else do we have here that's changed?
Well, the one thing they did give up, they gave up that we need to give all and sundry individuals. So it did take a long time. They did drop it to organisations. Because obviously originally when the bill was introduced, you had to give every individual and organisations. They did finally agree to drop the individuals, but it still is organisations.
Yes, so they would then want that information. If your child is spending, a time, which I'm sure they're going to still define, more than a certain amount of time with someone else.
That's the other bit. We can't give people exact details because the prescribed amount of time, we have to wait for a regulation. So at the moment, the prescribed amount of time could be an hour, but it could also be 12 hours. So we've got to wait, which the good thing, because that needs to be in a regulation, that means it can't come into place immediately because it needs another step by the government. So that does help with delay for us in one way.
Yes. So they would want that information. They would want address, postal address, and an estimate of total amount of time that a child spends receiving that education without any parent of the child being actively involved as well. So
and again, we don't know what they mean by actively involved at the moment. So if you're using sort of the web-based tutors and things like that, we've not been able to get a clear answer of what level of supervision from the parent counts as actively involved. So again, we're waiting for either the guidance or regulations to then let us know what is and isn't in scope, which I know isn't very helpful, but unfortunately that's the point we're at.
Okay, so they're also going to, as far as possible, they say that to the extent that the local authority has the information or can reasonably obtain it, A register must contain such information and things like child's protected characteristics, whether the child has any special educational needs.
Key bit though to notice about this part of the list, what we gave earlier is what you as a parent must provide.
Yes.
We're now on the stuff that they can ask you for.
Yeah.
But you're not mandated to give this to them.
Yes.
But they are allowed to stick it on the register if they have it. So if they already have this information, they can put it on there.
They're allowed
if
to make inquiries.
They can put it on there. But you don't have to give up. The other stuff you did have to. This you don't have to give up to them at this time.
And so it includes things like whether any inquiries have been made under Section 47, whether the child has ever been a child in need, whether they've been assessed as having needs. So there's a whole lot of things there, and I'm not going to get into all of that because that could also change. So moving on, there's a Section 436D, which is about the provision of information to local authorities by parents. And then it says what the parents need to provide the authority on request. So this is all Section 436, what information they must provide. The person must comply with the duty under subsection 1 or 2 before the end of the relevant period. So within 15 days of the child becoming eligible for registration by a local authority, this is the information that must be available for the register. So there's a whole section on that, on what parents must provide, but then we come to the provision of information to local authorities by education providers, 436E. And 436E puts a duty on these education providers. So, for instance, your online providers, or if your children are attending like tutor sessions or anywhere where they're receiving education, depending on whether that thing about prescribed time might come under that time period, but if that's still to be decided. But they will be required to provide information about your child. So remember, in your duty as a parent, you had to provide information of who you're using. The local authority can then contact that person.
And this one has always been really interesting to me. So I am a maths tutor. I have, for example, a home educated child who attends for 1 hour a week for a maths lesson. Okay. Now, it might be that they say providers must be providing 5 hours or more, and then we need to know who they are. I don't know where this child lives, by the way. I don't have their address details. I've got mum and dad's phone numbers and email addresses. I don't have their address. So some of the stuff that they're asking education providers, they haven't thought this through at all.
It's going to require local providers to collect information they wouldn't necessarily need to collect. And then they're holding data on these children, but then they're also required to provide that information back to the local authority. And not only that, they also have to provide information of any child that has attended with them in a 3-month period prior to the request.
But only the children who don't go to school.
Yeah.
So most of my tutees go to school. Now, I wouldn't necessarily know which ones were home educated and which ones went to school.
Yeah. And I think this is quite a nasty one, because these education providers can potentially receive a penalty if they don't comply. I just think that's terribly unfair, and it's going to change the nature of how we interact with our providers.
Yep.
And I think it's going to undermine a lot of that.
The other bits to add in, it's not just about the local authority of where your child is. A local authority can ask for all children who are home educated within the last 3 months at your setting, and it doesn't have to be within their local authority jurisdiction. They've actually specified that in there. So you might live in, say, Southwark, but Lewisham could ask a Southwark provider for all the details, and they would need to give Southwark children, Lewisham children, Camden children all together. They don't have to be child specific. They don't have to say, we want the details of that child, which again, it's about trying to catch the net of those who may not have already notified the local authority, because they don't have to be child specific for the data. They can just request, and it can go back 3 months.
So
I only has 15 days. Well, a minimum of 15 days. So it's what the LA says, but they can't say less than 15 days to provide this information. If they don't meet the prescribed time, then they can be subjected to the penalty. And we don't know what the penalty notice is, because unlike normally when they specify, that's going to be coming later. Like a lot of this bill, it's coming in regulations or coming in guidance. So at the moment, the providers don't even know how much that fine might be if they try to consciously object to providing the information. They don't know what the risk is.
And like I said, I live on the border of 3 local authorities. I can get children coming to me from any one of those 3 authorities to have maths lessons. I don't even ask where they live. I have no idea what's going to happen to people like me. We don't know, do we? Basically, we don't know. Are we going to be forced to keep records that we don't already keep? That's my question.
Okay, yeah. We come now to discussing the statutory guidance. And Michelle, can you perhaps tell us a little bit more about this?
Right. So currently at the moment, we do have EHE guidance, but we don't actually have to because it's not required by law to exist. It's done as from the DfE's perspective and the government's perspective to help all parties. But the bill itself is introducing that the guidance does have to exist. So the guidance will now take on a different frame. It would now be statutory guidance. So it would have more legal weight and LAs must then follow it. Whereas at the moment, they should follow it unless they've got a good reason not to. Whereas this then adds a different element to the guidance must exist. Current guidance doesn't have to exist. So the LA have to consider that in the light that the law is telling the government that they need to provide guidance to say how all these things are going to work and how the registers are going to work and all the nitty gritty detail that is missing. They have been very clear and they've said in numerous places publicly, the draft guidance will be out for consultation, and they have confirmed in several different areas that they've suggested a 12-week consultation period. Now, we don't know how soon after royal assent it will appear. It won't appear before royal assent. We strongly suspect it will appear quite quickly because we know that they've already been delayed substantially with the bill.
We've been working on it behind the scenes, yeah. And we would strongly urge every single person to respond to this as much as possible. It's going to be vitally important. I just want to quickly stop on 436G, which is support. And I noticed they've got to provide information about access to examinations, and they must offer a forum twice per year. And if at least even just one person is willing for that to take place, they have to arrange it. So I think this will be a powerful tool. It may be one of the only tools we have that we can use. So I'm glad that that's still in there. So my apologies. Originally, I wasn't quite sure it had because
I think the confusion might have come because that's one that Wales haven't taken on board. So the forum is an England only amendment in the children not in school bit. It's not a Wales one. So that might be where the confusion is. Wales have not taken on giving the forums, whereas England have put that in.
The next thing that we want to discuss is the pilot scheme.
I think we've missed out the considering the home.
Oh, we have, Okay, so very, very important one is the question about home visits, which I know many, many people will want to know more about. So this is something that we are going to have to deal with, and people are going to have to really consider how they're going to handle it.
First bit is when you actually become eligible to go on the register. So within 15 days of going on the register, the LA must consider where a child lives and may request to visit the child inside any of their homes. They must consider where they live. So they don't quite use the word home visit. So we can interpret that widely at the moment. That might change when we see guidance and regulations, but at the moment we can interpret that widely. But they've then got the and. But this is a may. So it doesn't mean they have to. But depending on your LA, you can probably guess where your LA might sit with the may request to visit the child, see the child inside their home, any of their homes.
Where we are particularly right now is Amendment 48.
Page 54.
Just at the end of 436B, before 436C. So they may request a child's parent to allow the local authority to visit the child inside any of the homes in which the child lives. And they say may, but then they say if a request under this subsection is refused by the person to whom it is made, the local authority must consider that to be a relevant factor in determining whether to serve a preliminary notice. So basically they're saying if the local authority asks for a home visit and you say no, potentially they could say, okay, right, well, we're going to serve you with a preliminary notice. So a lot is going to depend on your local authority and what they're like, because they don't have to ask for a visit. And there are probably some who won't want to. There are probably local authorities that are quite happy with the way they currently do things and won't feel the need. But if they do want to do something about it, they can then issue you with a preliminary notice on that basis. So,
I thought preliminary notice was the DFE's new way of referring to a notice to satisfy. Yeah, it's just their new lingo for it. That's all.
Yes. So notice to satisfy used to be to ask for more information. So this is basically, it's an escalation. So they'll ask for the information for the registers and about the child's education. And then if they want to escalate, it escalates to a preliminary notice. So preliminary notices are also have a bit in them about where you must consider where the child lives. They've brought that in there. And then it's also then basically at every stage now where they need to consider where the child lives. So this is something that we're not quite sure how it's going to look and what guidance might say about it. And parents will have to consider how they're going to respond to that. So 436H is the preliminary notice for the school attendance order. So it's basically telling you this is like your last step before a school attendance order. And this is basically explaining preliminary notice means a notice requiring the child's parent on whom the notice is served to satisfy the local authority that the child is receiving suitable education. Receiving education that is in their best interests. We have that term again. And I think it also ties in with Section 47 investigations, if that.
But
do you want to clarify that?
Right, the preliminary notices are different whether they're in the stages of whether they're musts or mays for how they determine to go to a school attendance order. So some of the consent categories have extra steps that the LA must consider as part of the preliminary notice, whereas the lightest considerations are the ones for just having not been on the register. So you didn't register when you should have done. So they've got lots of mays involved, whereas child protection section 47 is like must elements in there. So the local authority haven't got a choice whether they ask you to do certain things because it's a must in there. So the preliminary notice, depending on whether you fall in a consent category and which consent category, depends on what the LA must or may do with you when deciding whether to escalate your preliminary notice up to a school attendance order.
And obviously the bill, we've all found it quite heavy going to read. It is quite tricky to understand because they put in these things where you have to back and forth to check what condition C, condition D. Sometimes you have to go and look what was condition D again. I can't remember. So Amendment 78 is the one where it says for the purpose of determining whether a preliminary notice must or may be served in respect of the child, the local authority must consider the settings where the child is being educated that the local authority knows about and where the child lives, and may request the child's parent on whom the preliminary notice would be served to allow the local authority to visit the child inside any of the homes in which the child lives. Once again, if a request under subsection 7A(b) is refused by the person to whom it is made, the local authority must consider that to be a relevant factor. They must consider, not may consider, they must consider it a relevant factor in determining whether to serve a preliminary notice. So that comes in there at that preliminary notice stage again. And then we go, then the next escalation is to the school attendance order. I think one of the issues with the school attendance order is that it's not only about education anymore. Am I right, Michelle?
It depends on which condition you come under. So there's an education element, but there's also, for some conditions, the best interest element. So this is the difficulty. At the moment, if you end up with a school attendance order, if you can demonstrate that your child is in receipt of a suitable education that's full-time, efficient, and suitable to their age, ability, aptitude, and factors in any SEN, then you can be acquitted because that's a complete defence. Whereas depending on the reason you end up with the school attendance order, depends if it's only suitable education or if it's a suitable education and it's in the best interest for your child to not attend school. So this is where it gets tricky, because obviously that then becomes a lot harder to defend against, because this is a criminal offence. Criminal cases don't tend to look at best interest. That's always been a family law type element. So you're now in a really weird situation of trying to prove something when you're not quite sure what the criteria is, because it's not looking at what you've considered in your best interests. It's looking at what an external body believes is in the best interests of the child. And because it's like the LA considers it's in the best interest of the child to attend school, and obviously if they're being unreasonable, the judge will be able to make a decision differently if they're being unreasonable. But the problem is we don't know at the moment what the criteria is going to be for best interests. And that's not so easy to prove. Whereas it's a lot easier to demonstrate if your child is receiving a full-time efficient education suitable to their age, ability and aptitude, and the local authority just missed the point of your education. That's very easy to defend. It's quite difficult having this extra element, but it's not every child who'd fall in scope of that. It depends on the reasoning you get there. So once the bill is completely finalised, I'm sure several of us will put together flowcharts of, if you're condition A, this is the pathway. If you're condition B, this is the pathway.
It'll be about 20 flowcharts, I think.
It would be quite confusing because it's changed so much. But we can probably start working on that now. So then it will be easier for people. And we will certainly encourage people to ask in the guidance consultation that the DfE should produce, let's be fair, to be inclusive, should produce the flowcharts for each condition. So I think that's something we would definitely be recommending people ask the DfE to put in the guidance, because it should be easy for you to see, okay, where do I fit? I've got my preliminary notice because I wasn't on the register. Right, this is what is a may, this is what is a must. These are the steps. This is what I need to defend. No, I've got it because of child protection plan. Oh, okay. There's a lot more musts in here. My LA, I can't really discuss it with because they haven't got discretion. It's a must. Whereas this category, oh, actually, my LA could work with me. It's a may. It's their discretion. I can push back here, but it'll be something we will be strongly encouraging people to include in their responses to the consultation.
So for about,
we will also generate something ourselves.
Yeah, for about 10 years, I've been trying to get the DfE to produce flowcharts because things are too complicated. And they used to have a flowchart in the first proper official guidance that we had for home education. They had a flowchart. And I know this because my colleague Jill Fisher drew it on the back of an envelope and told them to put it in, and they put it in. And it was absolutely brilliant. People understood the process, blah, blah, blah. Then they took it out. I said, why can't we have flowcharts? And they said, oh, it's some technical reason. And that is the excuse I've been given for the last 10 years for them not putting flowcharts in.
Because it's so complicated, they can't even write them out. I want to go back to Amendment 80. So this is once again the home visit coming out here. The purposes of determining whether an order must be served under this section in respect of a child, the local authority must consider the settings where the child is being educated that the local authority knows about and where the child lives. We've got a question about, will it be a one and done home visit, or can they visit each time they gather information? So
anyone who tries to say a categoric answer to this doesn't know.
Yeah.
Because this is where we're waiting for regulations and guidance, because we don't know what's going to be considered the LA's criteria for working out suitability of education. And this is part of the reason why we will be actively saying respond to the consultation. Now, I'm someone who has publicly said, I've said I'm happy to go to prison on this. I am not going to have a home visit. My child does not want them. They've categorically made that clear. I've already made it clear to my LA. I will not be complying. However, that's a personal decision I've chosen to make with the full knowledge, the potential, if I got prosecuted under an SAO, is the potential of a high-level fine and or prison. I'm fully aware of that. I'm also fully aware that's not a risk many people could take. So we will be strongly encouraging people to put in those consultations the bits about the risks of a home visit, how intrusive it is. And again, if you would like that to happen, that is fine. But remember, just because you like a home visit doesn't mean other people would. And there are many reasons why. A person may have a disability. They might have to have a commode. And just from a basic dignity point of view, they might not want someone coming in and seeing the fact they've got to use a commode, or being told their environment's not appropriate for higher education because they've got a disability and have to use a commode. So there are many reasons which people don't necessarily pick up on why people wouldn't want the home visit, beyond the bit of like, actually it's your home and you should be entitled to have privacy. We would hope they wouldn't be wanting repeated, but no one can genuinely categorically say what the answer is right now. We need to wait for those regulations, and we need to wait for that draft guidance. And we all need to ensure that we lobby our MPs, and we need to start talking to councillors, because in your local authority, your councillors will be the ones that will be able to influence how your local authority implements it. They can't change what the law ends up saying, but where you've got things like consider this and it doesn't specify visit in the home, there are different ways of considering. So we need to be influencing the best we can.
Yeah. So, and I think also this is where different local authorities will also handle it, and the guidance is going to be so important. And it will be very important in the consultation that we do bring up these things of, can it be a one and done? Can it be that it's just a one thing, and if they've checked once that they shouldn't come back again? We can put in those things in a consultation, because otherwise, if it's left too wide open, there's always the chance that it
I just want to answer a question in the chat. Now, technically, in the bill, they haven't actually stated that they can move the data across that they've already got onto the mandatory register. So they haven't stated that, but then obviously they've also allowed themselves information sharing and things like that. The duty is on you as the parent to notify the local authority, because the other bit is, under the current regulations, when you leave school, the LA gets told by the school, but they're making the duty on the parent. So we don't know yet if they're going to do a passport scheme, because in the face of the bill, they have not included a clause that says they will passport you across from their voluntary registers. For those of us who've tried to get our data erased, we question the voluntary nature of these voluntary registers. So the bill doesn't mandate that they transfer it across. So we genuinely don't know. I would presume that they will just passport across, but whether they should or shouldn't, the duty is on the parent to notify the local authority that they are eligible to be on their registers. Now, if you have signed a form and agreed to be on the register, because I know there are some local authorities that do send a form out and you sign and say, I'm happy to be on your register, you've already notified them, so they could easily justify you're already on it. But for those of us who've been put on it and have actively said we don't want to be on it, it becomes a bit of a grey area, and it doesn't specify in the face of the bill. So we will have to look to see how it pans out. It may be they write in the guidance that anyone already knows is automatically moved across. But equally, if it remains silent, it will depend if anyone challenges them being put automatically on a register, or if an LA behaves in a way where they start issuing preliminary notices to all the parents who, within 15 days of the law being enacted, and enacted is not the same as the law getting royal assent. There'll be a long time before it's enacted. It's different. So you might have local authorities that will choose it as a way of 15 days after to go, oh, preliminary notice to all of you, because we may give you them all. So we genuinely don't know at this stage. We know what common sense would say you'd do, but they didn't include it in the bill itself. We can make a guess, but we don't categorically know what they'll do.
Okay, great. We want to move on to the pilot scheme. So the pilot scheme is something that was an amendment from the House of Lords, Baroness Smith.
It was one of their nice last-minute amendments that they like to add in. And it's one that won't be immediate because it requires regulations to happen. But when the regulations exist, the regulations will include which local authorities. So the regulations are going to name the local authorities that will be participating in the pilot.
It's 434B.
The pilot will be up to 30% of LAs in England and Wales. Now, that could mean it's 30% in England and 30% in Wales, or it could be up to 30% collectively across England and Wales. It could be interpreted either way, but that's the cap of the maximum. It will be a big change, and the pilot will run for between 2 to 5 years, and then it will be evaluated to see if it's going to be rolled out wider. But the pilot can't start till the regulations exist. Once they exist, we will know exactly which LAs. We do know what it's going to involve, though. So if your LA ends up to being one of those listed in the regulations as being part of this pilot, there will be mandatory meetings. So when you tell your school, I'm deregistering to home educate, you will not be allowed to stop your child attending. The LA will arrange a meeting that you must attend and participate in. It doesn't even allow you to just attend. They're requiring participation. The meeting will require a discussion of the LA explaining to you what home education is, what your role is, what their role is, what the responsibility is. Why are you choosing to home educate? Lots of different things. There's a whole list of it. The worrying thing for me, not only is it a mandated meeting, they require the child to be present. Now, I've already raised this several times. If your child has been assaulted in school and you're withdrawing them for that reason, to make them sit through a whole discussion about that is just cruel. Another bit they're going to be bringing up, bearing in mind you're the parent of the child, one of the things the LA needs to discuss with you is the safeguarding and welfare of your child in this, and anything relevant to your decision to withdraw the child from school, which becomes a bit ridiculous because you already know why you're withdrawing. But this doesn't mean then, once because you've attended the meeting, that now your child is off the roll. No. The LA must communicate to the school that you have attended the meeting or that you didn't attend the meeting. It's not very clear what happens if you didn't attend the meeting, because it does require you here that a parent must attend and participate in the meeting. So it's not very clear what happens if you didn't participate. So there's no time frame for when this meeting happens. So at the moment, if I put in my deregistration notice today, my child's not going back tomorrow, all hunky-dory. But you can see this could end up being a very long time frame, because there's no time frame for when the meeting can happen, but your child must attend until the meeting's happened. There's no time frame for when the LA must communicate to the school that the meeting's happened. So this could end up being a very substantial length of time, in which case your child has to keep attending. And if you're trying to withdraw your child because there's a mental health breakdown and there's potential crisis reasons, this could be unthinkable. And then there's also an element there of a representative of the school can attend the meeting, but that's only if the parent consents to their attendance. Now, this can be read several different ways. I know of the way apparently it's supposed to be read, because there are several parents who actually get frustrated that they feel the school hasn't done what they can to safeguard their child, and they would like their opportunity to explain to the school what you did was wrong. That's why it's not the LA to invite the school in. It's you, the parent must consent for their attendance. The school can't automatically be there, but there is the expectation for the child unless exceptional circumstances apply. Now, this is every child of compulsory school age. So a child of 5 or a child of 15 should be present for this meeting discussing all of this stuff. However, it isn't supposed to stop you from deregistering, but it is a significant delay. And it also tells them that you have to discuss all their support needs, all the reasons why you're considering it. So it's going to be quite a substantial, intrusive meeting.
Yeah, I agree. And it is a pilot study, but it will affect 30% of local authorities and the people that live there. And I think the concern is that it will kind of not even automatically be rolled out, but just kind of quietly sneak across the country as neighboring local authorities start to take their cue from. That is my concern, is where it'll creep into expectation.
And I think the difficulty is we already have some local authorities that effectively do this, and we know it's not law because they're trying to create regulations.
We had a question with somebody up here saying, are there any known tactics that schools do to stop home education? And this is a pertinent point.
We know of some schools that do a malicious safeguarding referral, which obviously has a whole load of extra worries here with regards to the element of them, whether you then move into needing consent to deregister, even though you didn't need consent at the point you tried to deregister. But obviously with the delay that comes in with the pilot, that ends up being a big issue. The other bit is, particularly when your child has an EHCP and there may be quite significant funding going into the school, but your child's not attended for donkey's years, so the money's going in, but the child's not getting the education. We do see at times there where all of a sudden the school will call a meeting, convince the parents it'll all be different, and then give a little crumb of something. And the parent then believes the school's doing everything they can to assist. And so then the parent doesn't deregister because they let their child go in part-time, and they don't realise that if your child then reattends the school after you've given your deregistration notice, you invalidate your own deregistration notice, because in your notice you include the day that your child's no longer going to be attending the school. So by then them reattending, your child doesn't come off the school roll, legally doesn't come off the school roll, because your child is still attending the school. So there are tactics that are used, but it depends on the child. Equally, schools sometimes advise the parents that their child would be better off home educated and better off not at the school.
Well,
so it works both ways.
Have you looked at the question on the screen? How would this work if you have complex needs children?
If you have a child who's enrolled at school, in other words, who's on the school roll, then this would be, it wouldn't apply, because the children not in school register doesn't apply to children who are enrolled at school.
It can't. No, Alison, it can at the moment. They've said that they're going to, in regulations, rule out of scope. So if you read the accompanying documents, in theory, you will go on the children not in school register at the moment, but they'll be known about because you're on the SEN register at the LA. But theory from reading the accompanying documents is they will be ruled out of scope.
And this is exactly how clear it is.
Yeah. So this particular question was about if you've got a child who's been registered, but they can't access school. How does this work? Because actually, as far as I'm concerned, they're technically, if this child is still enrolled at school, the school has a duty, the local authority have a duty to make educational provision for this child, don't they?
This is the cohort that I spend most of my time helping at the moment. And when this bill came in, there is nothing in this bill that improves the lives of these children at all. And they are actually the cohort of children of school age that I am most worried about, because many of them are undereducated or not educated at all, because for years the local authorities have been able to dodge their way out of providing what they're legally supposed to, which is education other than at school. It's an absolute travesty, and there's still nothing in the bill for them. So they might be ruling them in or out of scope, but they're still not going to do anything to help them.
Yeah, but it was quite interesting. One of the I can't remember which baroness it was now, actually brought up the bit, part of the argument for the best interest bit with the special school bit is that actually if it wasn't in the best interest for the child to attend school and they had SEN, actually that means you're saying it's not appropriate for the child to attend school. So legally that then pushes you into the EOTUS category, and that maybe it's more appropriate that they then offer you EOTUS rather than you home educate. And obviously that comes with a whole nother can of worms, and the SEN reforms haven't even mentioned EOTUS, so who knows where EOTUS is going to sit.
So I want to move on to our final bit that we need to discuss. So school attendance orders and penalties. What do parents need to know?
The school attendance order is pretty much as it is now. If you don't satisfy what needs to be satisfied at preliminary notice stage, they can escalate it to a school attendance order. Once the school attendance order is in place, you still have the opportunities to try and get it revoked. It still has the option, although whether we're convinced it is a mechanism that works or not, there is still the option to contact the Secretary of State to have it revoked because you're not happy that the school attendance order has been put in place and you believe it's been put in place incorrectly. That still is maintained. That still exists. The school attendance order will still name a school that they expect you to enroll your child in. You still have the option to enroll your child in that school, to have the conversation with the local authority to say, actually, I don't want that school, I'd like that school. Can we vary the order and then enroll them in that school? You still have the opportunity to request to revoke and meet what they were asking for in the preliminary notice. They don't have to agree. And you still have the option to continue home educating and breach the school attendance order. Now, the government's position is they believe the punitive measure they're putting in place is the school attendance order. Barron's words were, what's the worst that will happen? Your child will just have to go to school. However, if, like myself, you are committed to home educating and your child is clear they want to be home educated, you're not going to be enrolling your child in school. So what you need to be aware of, the school attendance order, the breach of that is that you have not complied with the school attendance order. The school attendance order is telling you, enroll your child in that school. People get confused over this and start going, but I'm doing this, I'm doing that, doing this. It's like a black and white decision. Either you enroll the child in the school or you don't. Now, if you don't, and you've gone past that time frame, you're now breaching it. You now potentially can be prosecuted, which is a criminal offence. But what you're prosecuted for is breaching that order, which is you're being prosecuted for not putting your child in a school. That's what you're being prosecuted for.
This is 436Q that we're looking at now. The offence of failure to comply with school attendance order.
Yeah. So then when you've breached it, when you fail to see there, you can ask it to be revoked and things like that. So this is the offence. You're failing to comply with the school attendance order. You're not failing to provide education for your child. That's not the offence. The offence is failing to comply with that order. And people often get confused with that. And quite often where people aren't acquitted in court, it tends to be they've misunderstood what they've been prosecuted for. Now, you will get the opportunity to say whether you're guilty or not guilty. Now, if you genuinely are providing a suitable education for your child, meeting all the Section 7 category, because that's still what it is at the moment, but you've got the extra element, if you're one of the conditions that requires best interest, you need to try and think how you will demonstrate that it is in the best interest of your child to remain with the status quo of being home educated and not to attend school. That becomes harder, and we don't know how you'll satisfy that. But if when you get to the magistrate's court, you are able to show that your education is suitable and you're in the category where that's all that's required, you can be acquitted and then get on with your life. If, however, you don't demonstrate your child is receiving a suitable education, the penalty has now increased. At the moment, the risk is quite a low-level fine, but they've increased the amount of the fine and they've added a prison option. And it's an and/or. So you could get just a fine, you could get just prison, or you could get a fine and prison. They've added this because they know that a lot of people won't even risk that. It will then come down to whether you can prove your case in the court that your child is receiving the suitable education. And if it's a best interest one as well, and you show that actually the LA are wrong, it's not in the best interest of your child to go to school. It is in your best interest of your child to maintain the status quo. And it will be a decision you'll have to make at the time. You right up to the point of being the morning of the court can demonstrate to the local authority and they can withdraw the case. But if you get into the court, you will either end up acquitted at the end, fantastic, or if you're found guilty, the risk now is they've added prison in as well. And that's something people need to be aware of because it's a bigger risk to take. As I said, I'm willing to risk that, but I know it's a risk that most people wouldn't be able to.
Okay,
and so you'll see here.
That's the nasty end of it. That's the stick. There's not much carrot, to be honest. There's not much incentive to comply, but there's plenty of negative reasons to comply. The other thing I want to say before we wrap this up is actually at the same time this is going on, there are several other documents out there that the government, they've been incredibly busy churning out this document, that document, and they all have impact and have interplay with one another. It is pretty much doing our heads in because they're coming out at such a rate. So we've got the SEND reforms and their white paper that also have impact on a great many people in our home educating community. We have all the documents on impact assessment that we need to look at. There's their memorandums and whatnot. I mean, there's so many of these different things. There's the keeping children safe in education consultation. There's what is the other thing that's out just recently?
What the working
white
together
paper
and the SEND white paper.
Yes, so that's what working together to safeguard children. These are all woven in and will have bearing, and some of them are not very nice to read, but we do need to. And I imagine our very trusty, helpful Kat will be putting these in the Substack, some of the links to these documents, so that you can go and have a look. But this is enough for tonight. But just remember there are support organizations, support groups and so on Facebook that will be there to guide you through if and when they become law, to guide and to let you know what's happening. But you do need to check in with them often to get the information. And we use our Substack as a way of getting information to people, as well as doing these lives at 8 p.m. on a Friday evening. Thank you to everyone who stuck it out with us for more than an hour. Thank you to Alison and to Michelle for their time. I hope that's left people a little clearer on things. Please share this video if you think it's helpful.
Fully finishes, just so people are aware, and I know Juliet's on part of the research panel, there will be, in the next couple of weeks, a questionnaire coming out. It is really, really important that you share it with all your home ed networks, because the information is going to be directly used by members of the House of Lords to try and address the myths and miscommunications that they've had. And the more people that fill it in, the more of the realities is there. And because it's being led by members of the House of Lords, it hits differently. I know they should just listen to us, but hey ho, we're just people. But when it's sort of led in that way and it's logged in the right way as official research and things like that, and a report generated at the right time, hopefully that will have influence on how regulations get perceived when they're laying. Because if that's out and the regulations quite clearly are going to do damage to us, there's actually a report that has standing that we can point to try and address any missteps in the regulations, and again address problems with the guidance. But the big issue we have at the moment is having the right types of report that get respected by the relevant people, because what we find is if it's believed to be just our own community research, it's ignored. It shouldn't be ignored. It's accepted all around the world, but it seems to get ignored by the government. So it's really, really important when the questionnaire comes out. I believe it's in the next 2 weeks. It should be shared. And I believe pretty much all the possible platforms that will be doing their best to get it out there. But if you can also get it out to those people who aren't on Facebook, aren't connected to us, because we really need to try and capture the full diverse home education communities that we are. Sorry, I'll let you carry on.
Yes, well, I just wanted to say,
free conference coming up. So
yes, I do have a conference coming up, home education conference coming up May 16th in Coventry. It's called Learn Free. You can go and look for it, learnfree.org.uk, early bird price currently. And we're going to have some amazing speakers there. So please do go and check it out. Alison's got a hand up. I want to just...
We need to mention Wales very briefly. If you are in Wales, please have a look. Ruth has been putting out a survey.
Ruth McKee.
It really needs to be filled in. We'll talk a little bit more about Wales next week, I promise.
Yes. But if you have found this video useful, please share it in your networks. Please share this video more widely for those who are still confused about what is happening with the bill. I think that's it for us. Thank you so much for your patience, and don't give up yet. There's still a lot we can do. Take care. Have a good week.